Good afternoon, everybody, and thank you all for your attendance this afternoon. Ashley and myself will be discussing issues in relation to insolvency changes. It's certainly been a very topical issue lately for people, particularly given what's transpired during COVID. So we hope that this afternoon's presentation will certainly be informative and place you all in a good position to understand where things were at previously, where they're going currently, and what our likely future prospects are going to be. So this afternoon's presentation touch on issues in relation to personal bankruptcy and some proposed changes which are very, very topical. We'll also discuss some industry reactions, and finally there's an opportunity for everybody through the chat feature to raise any questions or issues they want to, and Ashley and myself will, during this presentation, try to answer all those for you. Okay, the reasons for the changes. Well, the world certainly changed dramatically, particularly Australia back in March 2020. And that's when really COVID first really came to the attention of the Australian government and the public. So the pandemic has certainly proven to be an opportunity for not only our government, but governments around the world to examine and reform their corporate and personal restructuring frameworks. So the government recognised early in March that the economic impacts of the COVID pandemic measures implemented to prevent its spread could see many otherwise profitable businesses temporarily face financial distress. So in an attempt to create some form of safety net for these businesses, so that when the crisis passed, they could resume normal operations, the government implemented, very quickly I must say, a number of temporary measures to insolvency laws to, in part, lessen the threat of actions that could be unnecessarily taken and force these businesses into some form of liquidation, closure, etc., and of course to save many, many jobs. So the temporary changes were initially put into place for 6 months, commencing 24 March 2020. They were subsequently extended to 31 December 2020. Some of the temporary measures put in place by the government included the following: an increase in the threshold for creditors to issue a statutory demand in order to deem a company insolvent from $2,000 up to $20,000, so certainly a significant increase. There was also an increase in the time frame for which a company could respond or challenge a statutory demand from 21 days to 6 months, effectively taking it through the extension of the COVID period. And that 6 months was also extended up to the 31 December date also. Similarly, on the personal side, there was an increase to the minimum threshold for which creditors to initiate bankruptcy proceedings under the Bankruptcy Act, and that increased from $5,000 up to $20,000. And similarly, there was a increase in responding to a bankruptcy notice from 21 days up until 6 months. Temporary relief for directors from personal liability for insolvent trading was also implemented up until 31 December. Other temporary measures, such as introduction of JobKeeper, as well as from a number of financial and other institutions, including the tax office and the big banks, mortgage, tax, rental payment deferrals, from the Commonwealth and state taxes, there was deferrals as well, in order to assist and lessen the economic impact of COVID-19. So with all of these measures, with the exception of JobKeeper, ended on or before 31 December. And at this stage, JobKeeper is due to finish on 31 March. However, it is anticipated there will be some continued targeted spending. We've already seen it in the tourist market with the $800,000 discounted flights, and I'm sure we certainly expect there will be similar things in hospitality and possibly other industries also. So, given all these measures were only temporary, the government determined something more was required in order to deal with long-term financial impacts from the pandemic, rather than just this ad hoc approach that has been taken previously. So the government thought it was an opportune time in order to introduce some new legislation. So with the law reforms that have recently commenced, those reforms are all centered around the SMEs, the small to medium enterprises. And those industries have a significant role in our economy. As an example, 98% of businesses in Australia employ less than 20 employees, and 44% of employees in the private non-financial sector are employed by small businesses, and that represents about 4.7 million working Australians. So as a result of the pandemic, it is likely that a number of SMEs are going to need to restructure, either operationally, financially, or both in order to survive, while others may end up ceasing altogether. We'll touch on now the recent industry landscape and how the industry has fared. It would seem that the measures implemented by the government and others have worked remarkably well to reduce the number of insolvencies. However, they do skew the economic impact somewhat of the pandemic and mask the underlying issues. Their success also raises an intriguing question. How many businesses are still operational today that would have become insolvent in an ordinary year of operation? Looking at some of the statistics, so if we look at the 2020 numbers as on the slide, the dark bar being on the left being last year's, you will see that ASIC, or an average of the last 5 years, ASIC reported a staggering low 946 new external administrations during the September quarter, when compared to an average of 2,367 in the previous 5-year average. So that's a 60% decrease. And when you also examine the March and June quarters, they were also down 7% and 47% respectively when compared to previous year averages. December figures, while staggeringly low, were a slightly lesser decrease on previous averages, and they were still 48% down nevertheless. So these variances certainly suggest there are a considerable number of unviable businesses being propped up by government support and other stimulus that would otherwise have entered into some form of external administration. And these are those companies, you may well have heard this term before, zombie companies or zombie businesses. If we turn our attention to the personal side, the individuals, again, we see a very similar trend if you look at the charts up there. So personal insolvencies for the for the calendar year 2020 were significantly down, especially in the September and December quarters. There were 6,093 personal insolvencies recorded in the September 19 quarter, 1,663 people in business, 4,430 non-business. This is down 51% on the same quarter, which saw just 2,988 in total personal insolvencies. Similarly, the decrease for December is also approximately 54%. So let's turn our attention now to recent industry landscape. The question on many business owners' lips are this: have we managed to avoid significant economic fallout from COVID, or for the most part anyway? And now have we begun a new phase of recovery and growth, or are we simply in this calm before the insolvency storm? Only time will tell the true answer to that question. With JobKeeper ending shortly on 31 March, those businesses which have been relying on this and other support measures introduced to survive will suddenly find themselves having to manage higher costs, no longer having the protection from desperate creditors who've been waiting in the wings to have their debts paid. The latest in a series of measures introduced to assist is the economic impact of the pandemic, is the Corporations Amendment Corporations Insolvency Reform Act 2020 Commonwealth. Certainly got a very long name. These reforms are touted as the most significant reform to Australia's corporate insolvency regime in almost 30 years, and introduces 2 restructuring and insolvency processes for SMEs. Firstly, being a simplified debtor in possession restructuring process. So what that effectively means is where one of those appointments commences, the assets remain with the company as opposed to a liquidator taking possession of those. And secondly, a much simplified liquidation pathway. So the main objective of the legislation, and I will point out that this legislation was formulated, drafted, put out for submission, and then finally enacted in an extremely short period of time. And like with any rushed legislation, I think rushed legislation can be poor legislation, and there are certain anomalies, there are certain idiosyncrasies and difficulties which will need correcting at some stage down the track. However, the main objective of the legislation, the rush legislation, is to help small and medium enterprises in Australia overcome economic, financial and operational challenges caused by the COVID pandemic. These reforms are intended to reduce the cost of external administration for small businesses and the compliance burden for insolvency practitioners, thereby assisting more businesses to remain viable or increasing returns to creditors and employees in situations where such businesses are not viable. Legislation has been available for eligible small businesses since 1 January, even though the legislation, rules and regulations were only released late in December 2020, which only allowed practitioners like Ashley and myself a very, very small window of opportunity in order to become well versed with the new forms of legislation.
Okay, over to me. All right, so there is 2 new processes, as Nick mentioned, the new debt restructuring, a debtor in possession process, which we'll have a look at first. So some of the basics of that new restructuring process are that it's a restructuring process, it's a debtor in possession model that allows eligible companies to retain control of the business, properties and affairs of the company, while it develops a plan to restructure the company's affairs with the assistance of a small business restructuring practitioner, or an SBRP for short. It also then allows the companies to enter into a restructuring plan with their creditors. The process itself has 2 main steps. The first is an initial 20 business day period after the appointment of the restructuring practitioner, in which the company can propose a restructuring plan for consideration by the creditors. This is referred to as the restructuring proposal period, and this period can be extended by the restructuring practitioner or the court by up to 10 business days upon application of the company. But this extension is only available to be made once by the restructuring practitioner. So you need to get all of your ducks in a row before you determine whether you're going to proceed with the process. The restructuring practitioner does not take control of the day-to-day affairs of the company. Rather, they act as the company's agent with their main role to provide assistance to the company about restructuring, assist the company to prepare a restructuring plan, and also then to make a declaration to the creditors of the company about the plan proposed by the company, whether or not the eligibility criteria have been met, whether the company is likely to be able to discharge the obligations created by the plan, and any details of related party creditors that the company may have. The directors of the company remain in control of the company and may enter into a transaction or dealing with the assets if it is in the ordinary course of the company's business. Consent from the restructuring practitioner is required for transactions involving company assets that are or may be outside of the ordinary course of the company's business. So the eligibility criteria for the debt restructuring process. So on the day on which the restructuring practitioner is appointed, total liabilities must not exceed $1 million, and this does exclude employee entitlements that may be outstanding on that day. The directors and former directors of the company have not been directors of another company that has undergone a restructuring or followed the simplified liquidation process, which we'll discuss soon, and that has to they have to have not been part of those processes at any time in the past 7 years. In addition, the company itself has not undergone restructuring or a simplified liquidation in the past 7 years. So if the criteria are met, the directors of the company pass a resolution that it is insolvent or likely to become insolvent, that a restructuring practitioner should be appointed. The restructuring practitioner must consent to the appointment prior to it commencing, and they must be a registered liquidator. The remuneration of the restructuring practitioner is set before the appointment, and it's set by the company's board. It must be for a fixed amount, and there is an additional method for calculating the restructuring practitioner's remuneration for dealing with the proceedings, and that must be consented to by the board in writing. Okay, so just some terms that are quite common in this process. So firstly, an infected creditor. So an affected creditor is one who would be a party to the restructuring plan if it were made, or a creditor of the company who is a party to an existing restructuring plan that may be being varied or terminated. There are some excluded creditors to this process, and they are the restructuring practitioner themselves, a creditor who is related to the company at the time the restructuring began, and a creditor who, on becoming an affected creditor, is a related entity of the restructuring practitioner. So an example of that might be the restructuring practitioner's firm, who might be owed some money for some advice. That doesn't preclude the person or the individual being the restructuring practitioner, but it does preclude their firm from taking part in the restructuring process. And another term used frequently in this process is an admissible debt or claim, and that's one that would be admissible to prove against the company if the company were wound up, and that's either as at the date the restructuring began, if a plan hasn't yet been made, or if a restructuring plan has already been put into place, the amount owing as at the date the restructuring began. Employee entitlements are excluded in the case of restructuring, even though they would ordinarily be admissible. Okay, so how does the restructuring process work? A distressed business approaches a restructuring practitioner or registered liquidator who will need to confirm the eligibility of the company to enter into a restructuring process. The board or the directors of the company then appoint the restructuring practitioner. Creditors receive notice of the commencement of the new debt restructuring process and details of how to access important and necessary information about the restructuring process. Company directors then develop a restructuring plan with the practitioner, and the restructuring practitioner provides the restructuring proposal statement for the monitoring of the plan. So before proposing a restructuring plan, the company will need to have a few things already done or in process. So firstly, they need to have paid all employee entitlements that are due and payable, and that's not future liability, so not long service leave entitlements and that sort of thing. It's just wages, superannuation and leave that is currently due and payable to their employees. The company also needs to have lodged all returns, notices, statements, applications or other documents as required by taxation laws. Payment of outstanding taxation debts need not have been made, but the lodgements need to have been done. Just an important point on that, that the director of the company should consider the above 2 points. Consider whether the company will have complied with these 2 criteria, because the company won't be able to even propose a restructuring plan if the entitlements and lodgements haven't been attended to. Okay, the restructuring practitioner will issue a report to creditors within 20 business days of being appointed, and that report outlines the company's restructuring plan, standard terms and conditions that apply to all restructuring plans, a certificate stating whether or not in the practitioner's opinion the company meets the eligibility criteria and whether the company is likely to meet its obligations under the plan, and also include a restructuring proposal statement which includes a schedule of debts and claims of the company and the creditors, as well as details of the proposed remuneration for monitoring the plan. Once that report has been issued, creditors will have 15 business days in which to consider and vote on the plan and the restructuring practitioner's remuneration proposal. If more than 50% in value of creditors, which excludes related party creditors, approve the plan, it is then binding on all unsecured creditors, and the restructuring practitioner will then be appointed to monitor the progress of the restructuring plan. However, if the plan does not receive 50% in value of eligible votes, the process will then end and the directors of the company may choose to enter into a formal voluntary administration or liquidation process. However, this is not a mandatory requirement. So that it may be that the company simply falls back into how it was before attempting the restructuring process. The plan itself. So the plan must be in the approved form. So there is basically a template that is available for companies to be able to do this process. The restructuring plan must identify the company, some of the company property to be dealt with. It must specify how that property is to be dealt with, provide for the remuneration of the restructuring practitioner for the plan, and lastly, specify the date on which the restructuring plan was executed. However, it must not provide for the transfer of property to a creditor other than money, and it must not allow for payments to be made to creditors, admissible claims, for a period exceeding 3 years after the acceptance of the plan. So all of this process needs to be wrapped up within a 3-year period from commencement. Okay, so the restructuring practitioner can immediately stop the restructuring process if misconduct by a director, shareholder, employee, or other party is identified. Related party creditors are prohibited from voting on the restructuring plan. From the appointment of the restructuring practitioner, unsecured creditors and some secured creditors are prohibited from pursuing enforcement action against the company or enforcing personal guarantees. If there happens to be a court... Sorry about that, we've got a bit of a fire alarm test going on.
System is now complete. Please respond to all further alarms.
Okay, so in relation, if there is a winding up process that has been commenced, the court may choose to examine whether it would be in the best interest of the company's creditors for the restructuring process to continue. And if it's not, it may determine that it's the best process is to continue with the winding up action that's on foot. So there are also safeguards preventing the implementation of ipso facto clauses during the restructuring process. And whilst the period has almost elapsed now, it's currently eligible small businesses will be able to declare their intention to utilise the process from 1 January via a publication of a notice on the ASIC website. So what that is ability for companies to lodge a notice with ASIC to provide an intention to enter a restructuring process, and that gives them a little bit of leeway with their creditors while they try and determine whether the restructuring process is the best process for them. If they did lodge a notice or do lodge a notice before the end of this month, then they need to actually start the restructuring process by the end of the month. So obviously that window is shutting very rapidly. Okay, so once a notice is published on the ASIC website, the directors will receive relief from insolvent trading liabilities, enforcement of director guarantees, and statutory demands until the appointment of a restructuring practitioner. So it does give them that little bit of leeway while they work out what's the best path to take for the company. All admissible debts and claims rank equally under a restructuring plan. So there's no creditor or class of creditor that receives a priority in repayment of their debts and claims under the restructuring process. Payments made by the company in the ordinary course of business during the debt restructuring process or with the consent of the restructuring practitioner will be excluded from subsequent insolvent trading claims in the event that the company does ultimately enter a formal liquidation process down the track. Otherwise, secured creditors will require the leave of the court to commence enforcement action during the restructuring process. Debts incurred during the debt restructuring process are provable if the company is subsequently wound up. So that's just some of the fine print. It is quite a complex piece of legislation, the new debt restructuring process. So we've touched on some of the major points here. If anyone does have any specific questions about that process, we'd certainly have an attempt at answering those questions.
So really what that process is all about for a company is a very quick, a relatively inexpensive, or meant to be more inexpensive than any current legislation or current formal winding ups, etc., and in order to allow them to continue. One of the criticisms I have is the $1 million threshold in liabilities can be, and that does include secured creditors. So when you take into consideration all such creditors, I think it's a very, very tough threshold, and there may not be a lot of businesses that will fit just within that simple criteria. Anyway, time will tell.
Okay, so the other new process introduced on the 1st of January this year is the Simplified Liquidation process. So some of the basics of that process. So simplified liquidations are not a new type of liquidation. Rather, they are a process within the existing creditor voluntary liquidation or CVL regime. Commonly referred to as a simplified creditors voluntary liquidation or an SCVL. And they apply to liquidations where the triggering event occurs on or after the 1st of January 2021. There are a number of different triggering events. The most common one likely to be the passing of a special resolution by members that a company be wound up. Other triggering events may be when the company transitions from a voluntary administration or from a deed of company arrangement, where circumstances exist that may terminate those types of appointments. They are only available in a CVL and cannot be adopted in a court liquidation scenario. The liquidator still has a statutory obligation to consider all avenues of recovery, including voidable transactions and insolvent trading, despite the simplified nature of this type of appointment. And the liquidator also still has obligations to report misconduct of the directors and others to the regulator, who in this case is ASIC. So the eligibility criteria, so there's quite a few for the simplified liquidation process. So I'll run through those briefly. So the first of which is that a triggering event has occurred. So I mentioned before, that's likely to be a resolution of the members of the company that a liquidator be appointed. The company director needs to provide a report on company activities and property, commonly known as a ROCAP, and also a declaration of eligibility, and they need to provide that within 5 business days of the meeting of creditors at which the resolution for voluntary winding up is passed. So it's a very short period of time. In the declaration of eligibility, the director declares that in their opinion on giving the declaration, that there are reasonable grounds to believe the eligibility criteria will be met and their reasons for that opinion. and also whether there are reasonable grounds to believe the company has entered into a transaction that would be avoidable transaction, and that's other than an unfair preference. Another criteria is that the company is unable to pay its debts in full within 12 months of the triggering event. The total liabilities on the triggering event day must not exceed $1 million, and this includes any current employee entitlements outstanding. The directors and former directors of the company must not have been directors of another company that has undergone restructuring or followed this SCVL process within the past 7 years. And similarly, the company itself must not have undergone restructuring or SCVL in the past 7 years. And the final eligibility criteria is that all ATO lodgements for the company have been lodged. And again, this includes all tax returns, notices, statements, applications, or other documents as required by any of the taxation laws. It is important to note that payment of outstanding amounts need not have been made. So that's very similar to the restructuring process we discussed earlier. How does it work? So if the liquidator decides to adopt the SCVL process, they must at least 10 days before adopting it give written notice to each member of the company. That includes a statement that the liquidator reasonably believes the eligibility criteria will be met, an outline of how the CVL process works, and then a statement that the creditor will not adopt an SCVL if at least 25% of the value of the creditors direct the liquidator in writing within 20 business days that they should not adopt it. So if the liquidator then decides that the SCVL process can and should apply, they must lodge a notice with ASIC within 5 business days of adopting the process. Okay, there is no requirement for the liquidator to prepare and lodge a report to ASIC pursuant to Section 533 of the Corporations Act, which is a report on misconduct identified during the course of the liquidator's investigations. However, there does remain an obligation to report misconduct that is or likely to have a material adverse effect on creditors or a class of creditors, where the liquidator has reasonable grounds to believe this misconduct was by past or present directors, employees, shareholders, or those who have taken part in the formation, promotion, or administration of the winding up of the company. The liquidator then lodges this report within 6 months of forming an opinion on the alleged misconduct. There are no meetings of creditors held or committees of inspection formed, and there is no ability or discretion to hold such meetings. Provisions relating to the convening of meetings do not apply, including the right for creditors and ASIC to direct that a meeting of creditors be called. Creditors do retain the right to make a request for information, but as the creditor meeting provisions have been removed, there is no ability for creditors to replace the appointee under a simplified liquidation process. So the Committee of Inspection requirements have also been completely removed, as there's no ability to hold meetings and appoint a Committee of Inspection. The 3-month statutory report that's normally issued to creditors in a normal CVL process has been substantially simplified. The report issued to creditors now only need contain 3 main categories of information. Firstly, an overview of the work done to date, the anticipated end date for the liquidation, and then the likelihood of a dividend to creditors of the company. Avoidable transactions remain recoverable. However, there is a reduced ability for a liquidator to recover unfair preferences from non-related creditors, as the clawback, what we call the clawback period, has been reduced from 6 to 3 months, and it's only available for claims of more than $30,000. So that's a considerable change to the normal unfair preference rules. In a simplified liquidation, there's only one dividend to creditors that can be declared and paid, and there's no need to formally call for proof of debts in a separate notice, as may happen under a normal liquidation. The 2-month time limitation around the issuing of notices of intention to declare dividend has been removed. And as only one dividend can be paid in this process, there is no ability to pay any equalising dividends. So once the dividend has been declared and paid, that is the only opportunity for creditors to receive a return from the company in liquidation. So it is important that creditors always keep their contact details up to date with companies, respond to liquidators' correspondence as appropriate. Otherwise, they may actually miss out on a return altogether during the simplified liquidation process. Okay, so 25% in value of unrelated creditors may direct the liquidator in writing not to adopt the SCVL process within 20 business days of the appointment of the liquidator. A point to note here is that if the direction not to adopt the SCVL process is received within the 20 business days, but after the SCVL process has already commenced, the direction not to adopt that's received from the creditor or creditors has no effect on the process. So once the SCVL process has commenced, there is no ability for creditors to request that it stop. The liquidator must adopt the SCVL process within the 20 business days of their appointment, or the option to adopt lapses. A liquidator must cease to follow the SCVL process if the liquidator considers that either the company no longer meets the eligibility criteria, or reasonable grounds exist to suggest that a director of the company has engaged in fraud or dishonesty, which has had or is likely to have a material adverse effect on the interest of the creditors, either as a whole or as a class of creditors. And finally, the liquidator must notify ASIC within 5 business days of ceasing to follow the CVL process. So again,
Okay, thanks Ash for that summary of the 2 new formal processes that are there. Whilst they might sound complicated, in reality they can operate quite smoothly. So if there's any businesses or you know of anyone who needs advice, we've got a lot more tools in our arsenal now to be able to assist and support those businesses to continue on as opposed to being closed down as they once were. Just to wrap up, excuse me, I will talk about some of the recent changes or proposed changes with respect to bankruptcy, personal insolvency matters. So let's go back in time. Back in 2017, during the Turnbull government years, there was a proposal that bankruptcy law in Australia be changed somewhat. And significantly, one of the major points of that was reducing the default period of bankruptcy from 3 years to 1 year. The reason for that was to encourage more entrepreneurship, to encourage more risk-taking, but at a level that's, of course, acceptable. Under that proposed regime, bankrupts were still required to make compulsory income contributions for 2 years, and it also reduced the period by which a bankrupt can seek to travel overseas and or obtain credit greater than a threshold limit, which is approximately $5,500 without having to notify the financial institution of their current bankruptcy. Unfortunately, that legislation never proceeded. Mr. Turnbull was thrown out, and that piece of legislation kind of fell by the wayside, has been sitting dormant effectively since then. However, what's happened is of late, the Attorney General's Department early in January issued a discussion paper seeking submissions on various amendments to the bankruptcy system. And again, the reduction of the default term of bankruptcy from 3 years to 1 was front and center of that. Submissions have closed in February. At this stage, there's no indication when the bill may be introduced. However, understanding is that it has bipartisan support And when that bill is reintroduced, it is expected that the default period will certainly be altered from 3 years to 1 year. There's certainly been a lot of objection within the profession to the reduction of 3 to 1 for a number of reasons. But I think when the bankruptcy system is looked at holistically, in my opinion, a change from 3 years to 1 is certainly well overdue. So what actually transpired and what's the position now with respect to bankruptcy? So at the conclusion of the temporary relief measures on 31 December, the federal government, in response to COVID, during the COVID period, has now increased the threshold from, let me go back one step. The initial threshold to bankrupt the person was $2,000. Under the temporary measures, it increased to $20,000. However, now there's been a permanent increase from $2,000 to $10,000. The response time for a bankruptcy notice reverts back to the normal 21 days. There's been no change with respect to that. And the normal time with which to lodge an intention, a declaration of intention to present a debtor's petition, in other words, a declaration that I intend to declare myself bankrupt, but I'm just thinking about it or getting advice on it. That period was also extended by 6 months, and it also now reverts back to the usual 21 days. So the only real change has been a permanent increase in the minimum amount in which a creditor must have a debt in order to bankrupt somebody. So how has the ultimate industry reacted both on a personal and a corporate sense? Well, firstly, let's touch on how the industry or how the economy has taken the new debt restructuring process. So it commenced 1 January. Since that time, there's been 22 advertisements lodged for declarations of eligibility for temporary restructuring relief. So it must be understood that these are only eligibility. They may not necessarily turn out into be a formal restructuring. There have, however, only been 6 advertised formal restructuring appointments undertaken since 1 January 2021. So it remains to be seen whether the SCVLs have actually simplified the liquidation process or it made an unnecessarily complicated and more costly to carry out. At this stage, there seems to be, as I previously touched on, literal industry support within the insolvency industry, that is, for the reduction of the bankruptcy period to 1 year for all bankruptcies, but there may be scope for the industry to explore some form of early discharge by way of keeping the 3 years and having those who classify or fall within some form of eligibility criteria able to be discharged after perhaps, say, a period of 1 year. Those of you who have been around a number of years would certainly be aware that there previously was an early discharge regime. That regime provided for applications to be made after 6 months, and after some consultation, that whole part of the legislation has been removed. So I don't believe an early discharge regime will again be enacted, and I believe that they will go to a 1 year bankruptcy. Watch this space. When we know, we'll certainly inform all our VinLink members as well.
I'd like to think, though, in introducing that new 1 year process, that they do put some pretty strict criteria as to who is eligible for it. And if in the case of an individual that declares themselves bankrupt multiple times, then that should really be considered as to whether it's appropriate to be discharging them after 1 year if they are known as what we call serial bankrupt. So there should be some, reasonable thought and consideration put as to how the whole process.
Yeah, I certainly agree. And one would hope, given this isn't rushed legislation, given that it's effectively been before the Parliament since 2017, there would be those safeguards drafted in. There would be those appropriate measures where those who are the recalcitrants, the repeat offenders, etc., there will be certainly harsher periods, harsher penalties as well imposed. I will remind everybody that the chat or question feature is certainly available. If you've got any questions regarding any insolvency related type matter or any matter in general, I know Ashley's and myself's contact details were very briefly put up at the front, and I'm sure they're available through the link you had for this afternoon session. Just checking the screen, there doesn't seem to be any questions or issues. Either that means we bored you to death, or alternatively, you understood and got everything you needed out of this afternoon's presentation. Look, I'd just like to finish up by thanking everybody for attending this afternoon. I hope it's been informative for everybody. And just to repeat again, look, reach out to us here at Vincent's if you have any questions, issues, or concerns regarding insolvency matters in general, or indeed if there's any topics with which you see, which you want to see us present to you upon, and we'd be more than certainly happy to do so. Without further ado, I think we'd like to again thank everyone for their attendance.
Thank you.
And have a great afternoon, everybody.